Asekun. Unfortunately, he is unavailable right now, so I will be the one presenting this week's podcast. So this week, uh, we're talking about a topic that's very important and a new development. But first, let me start off by saying that we do this podcast every Wednesday. We do it at 12 p.m. Central Standard Time. If for any reason, we're not available to do it, we usually post. But as I said, Dr. Shekun is unavailable, so I will be handling this week. Make sure that you follow us on social media and hit subscribe on YouTube, because that way you can get notified every time we go live. And if you follow us on, say, like Instagram or TikTok or X, Facebook, any of those, then you can also see updates. So those could either be short videos or little updates about the podcast or just anything that comes up in immigration news. There's also a bunch of short videos. We have podcasts about everything. We have short videos about a multitude of topics. So go ahead and check us out on social media. Our Instagram is up on the screen right now. Okay, let me go ahead and get into this week's topic. So this week, we are actually talking about a very important Supreme Court decision that just happened. So I want to kind of start with the background of marriage fraud, because this Supreme Court decision has to do with marriage fraud. Now, if you've ever listened to our podcast before, then you may have heard about something called a 204C determination. We say it a lot, 204C. So a 204C determination is when DHS or USCIS makes a determination of marriage fraud in your case. So that's when you're filing for a green card based on a marriage. So the I-130 is usually the one that gets the 204C determination. And the I-130 is the petition. So that's what the whole basis of the green card application is. So when you are applying for a marriage-based green card, you have to go ahead and provide evidence of that marriage. So that includes things like your marriage certificate, evidence of commingling of assets. So that's like bank statements, lease agreements, evidence that your bills are together, things of that nature, and then photographs together, anything that really has to do with you and your marriage. So when you submit everything, USCIS could request for a request for evidence, and then if there are any red flags, they will issue either a notice of intent to deny, or they will even go ahead and do an investigation into your case. So how that works is when there is a red flag, USCIS sends it to another department that goes ahead and actually looks into it further. So they do different searches. They could even possibly follow you around and just see like where you're actually living, if you are actually together. We don't know everything that they do. I mean, no one will know what they, do except for them, because that's not something that's released to the public. But if they do that investigation and then they determine that in their eyes, your marriage was entered into for the purpose of an immigration benefit, then, like I said, they could issue a notice of intent to deny, which will give you a chance to kind of go back and say, well, no, this is what happened, or this is why this is like this, and then submit further evidence to back up your statements. However, if after all of that, immigration determines that your marriage is based on fraud and solely for the purpose of an immigration benefit, then they will issue a decision notice, which will be a denial. And in that denial letter, they will issue what's called a 204C determination. And that just states that you entered into this marriage for the purpose of an immigration benefit. And it's always been a really difficult thing, because if you get a 204C determination, it's really difficult to kind of overcome that. And in a lot of cases, and depending on the administration, you may get put into removal proceedings, or it really just depends on a lot of different factors. But the most important and worst thing about a 204C determination is that you can never request for any other immigration benefit from the United States ever again. You are barred for life from ever requesting for any type of immigration benefit. So it really is a really big and troublesome thing. And in a way, it's actually why we do these podcasts. Kind of weird segue, but because we want to go ahead and put information out there that can help you stop making these little mistakes that could lead to something like a 204C determination. Because we've seen immigration do 204C determinations on marriages that we knew were legitimate. So it's a very difficult thing to overcome. And recently, there was a Supreme Court decision that now says that you cannot argue a determination of marriage fraud in immigration court. So, what that means is if you get put into removal proceedings, or if you were already in removal proceedings and you want to have the court kind of review that again, you can no longer do that. You can no longer argue in court on a marriage fraud determination. So instead, what you would have to do now is go ahead and file an appeal with the Board of Immigration Appeals. So again, the court, you can't go to court and try and argue that your marriage is legitimate. So another case where this could happen is, say, on if you got like a conditional green card, so that's the 2-year green card, you get that if you've been married for 2 years or less at the time of the approval of the green card. So, say for instance, you get that 2-year green card, and you then have to apply for what's called a removal of conditions. So, that's a Form I-751. And what that petition does is it removes the conditions on your permanent residence. So that means that, you know, you basically either have to attest that your marriage is still legitimate, or you can also, if you're no longer together with the person, then you can say that you did enter into the marriage in good faith. However, you're no longer together, but you did not enter into that marriage solely for the purpose of an immigration benefit. And then there's also different provisions, say if you were abused while in that relationship. And so those are just different aspects. You can go ahead, we have a podcast on removal of conditions. So if you want to kind of go into that in more detail, then you can go ahead and watch that. But for the sake of this topic, if you go ahead and file for Form I-751 and either jointly with your spouse still or on your own, and if that is denied and then you're put into removal proceedings, you can actually have the judge review that I-751. So that that's what it's called, is a removal of conditions review by the court. But now they're saying that if the reason for that denial was marriage fraud, you can no longer make that argument, and the court cannot overcome that. So the only way that you can actually overcome a marriage fraud determination now is by appealing with the Board of Immigration Appeals. That's the only way now. And so again, this was a new Supreme Court decision. It was in October of 2024, and it is kind of a big deal because, again, previously you could go to court and argue that your marriage was entered into in good faith. In fact, we even have a podcast about good faith marriage as a defense in removal proceedings. We have a podcast on that, so you should go ahead and listen to that if this topic applies to you. But now what they're saying is if it was a 204C determination, marriage fraud. You can no longer go to court and argue that. So it is really difficult because a lot of people could have the court review their case and, enter in more evidence in your case. But now that's no longer possible. It's only through the Board of Immigration Appeals that you can appeal that decision and then possibly overturn it. And then once it's through the Board of Immigration Appeals, once they make their determination, then that's final. And you can no longer have the court or anyone else review that again. Once the board makes their determination, if they reaffirm the marriage fraud determination, then that's it. Then basically you're done and you're barred from applying for any immigration benefit. So again, you really need to make sure that you're not doing anything that would lead to a 204C determination, because now it's just even more difficult to overcome. It was already very difficult, but now this Supreme Court decision just makes it so much more difficult for anybody that's trying to seek a green card through marriage. And hold on. Sorry, I'm just pulling it up to see if we've gotten any questions yet. So, oh, I'm so sorry. I just wanted to make a correction. October is when the case was argued. The actual decision was just last week. Sorry, I was trying to pull it up and see exactly when the actual decision was. Okay. Argued October 5th, 2024, and decided December 10th. Oh, that was yesterday. So this is really new. Okay. So now let me go and see. Go ahead and start sending us your questions. If you have questions about this topic, whether it be marriage fraud, this new Supreme Court decision, or any other questions, go ahead and start sending us in your questions so that we can start answering some of them. Well, hopefully all of them. Oh, okay. So yes, we have started receiving questions. So I'm going to go ahead and start to answer some of these. Okay, so the first question received via text: does 204C only apply to the petitioner or the beneficiary? Now, that's a very good question. So when the 204C determination is made, it bars the beneficiary from ever applying for any type of immigration benefit again. Now, typically, a petitioner would already be they would be a permanent resident or a U.S. citizen. However, if the petitioner is, say, a permanent resident, that could eventually lead to an investigation into their own case as well. So while traditionally it is mainly about the beneficiary, it could lead to an investigation into the petitioner as well. And even U.S. citizens, if you obtained your permanent residence and then eventually your citizenship through marriage, they could go back and look at that marriage as well. And it could come out that if you obtained your own permanent residence by fraud, then that could even lead to complications for the petitioner as well, because then they could begin either rescission proceedings or even leading to their citizenship being overturned. And another correction, the I-751 denial can still be reviewed by the immigration court and the appeal can go to the BIA. However, we can no longer appeal further. So that's what I was saying, that once you appeal it with the BIA and if they reaffirm the decision, then that is done. So you can't appeal it to the district court, the circuit courts, or even the Supreme Court, because typically you could appeal it all the way to the Supreme Court. Now, the Supreme Court doesn't typically take cases like that, but you could keep appealing it further. Now, now what this decision is saying is that once the BIA makes that decision, that is final. If they reaffirm that decision of marriage fraud, then that is final. You can no longer go to the district courts, to the circuit courts, or even the Supreme Court. And so going back to the question, so in the case where, say, you were born in the United States and you were already a citizen when you applied for the beneficiary, and if you received the determination of marriage fraud, then you can actually even be fined or jailed, because it could turn into a criminal offense. But and then the beneficiary becomes permanently barred. But yes, the petitioner, if they were a citizen to begin with, when everything started, say they were born here, then if that marriage fraud determination is made, then yes, they could be fined. They could even be jailed. And then the beneficiary is barred from ever applying for any type of immigration benefit. Permanently barred. Let's see. So I hope that that answers that question. And then the next question: how does USCIS determine marriage fraud under 204C? So that's another good question. So it can be several different things. Like I was saying earlier, if USCIS has any red flags on your case, and if they see something that makes them launch an investigation, then when they launch that investigation, they could see. Oh, sorry. Yeah. No, I'm using this one. Yeah. Sorry about that. Okay. So I. As I was saying, okay, so USCIS could send the case over to the fraud prevention team, and what they do, their sole purpose is investigating marriage fraud. So they investigate different types of immigration frauds, and if they suspect maybe you didn't answer correctly at an interview where you and your spouse were answering completely different answers for, very important questions. Like, for instance, how many people were at your wedding, or were you married in a church or at a courthouse? They can even ask crazy questions at an interview, like, what side of the bed do you sleep on? What color is your toothbrush? What color is your spouse's toothbrush? Where do you keep the dirty clothes in your house? Things like that. So they can ask basically any type of question about your marriage. And if the petitioner and the beneficiary have wildly different answers, then obviously that can bring up a red flag. And that can spark an investigation where then the prevention team goes in and does whatever tools they have to investigate. We don't know exactly what all they do, but in our experience, we've seen people being not necessarily kind of followed, or have USCIS or officers, the fraud prevention officers, even kind of like camped outside of your house watching who comes in, who comes out. Recently, they have been requesting for Ring doorbell footage. And if you give it to them, then, they can see who's coming in and out of the house. Is it really who should be coming in and out of the house? Or, is it just you? They can talk to different neighbors and say, hey, who lives in that apartment? Who lives in that house? Do you ever see this man? They can show, the picture of the person and say, do you ever see this person around here? Or they can watch like what cars are parked outside of the house, different things like that. And I mean, a lot of people think that USCIS, the officers, I don't know why some people think that they're stupid and that they're just not going to pay attention to inconsistencies such as that. But a lot of times, uh, they look at those little things, um, and it, they can really catch you on something small. It can be something so small that triggers a red flag that then can spark a whole investigation. And if, for instance, that investigation leads to another case, then it can mess up things for another person. And so it's really important, to not let that happen, to not let those little things add up and spark an investigation, because that can really lead to trouble. Uh, and then another another thing that could also raise a red flag, and something that USCIS does utilize and the fraud prevention team, they can check public records. So they can see things like, is this person getting mail at this address? What address do they have on their driver's license? Um, Anything like if you're applying for any type of public benefits. So, say the petitioner is a US citizen and they're applying for some type of uh, their, sorry, if the person is requesting for any type of benefits from the government, and if they put that they are single on, say, their application, and if they never update it and just get benefits as single, that could obviously raise a red flag. Even on unemployment or health insurance, anything that's in the public record, they can access and then see, okay, but they're saying that they're living at, 123 Fake Street, but they're really over here at, 456 Main Street or whatever. And it can really lead to a lot of issues, and then an investigation and a 204C determination. And another thing that's also pretty important when it comes to this topic is there is a BIA decision that says to overcome the marriage fraud determination with the Board of Immigration Appeals, the evidence that you submit, it must be substantial, um, and it must show that, it is a valid marriage. Because a lot of people, when they get even like a notice of intent to deny, they just ask for like, or they just provide like one or two things that immigration is asking for. And that's not enough, even for USCIS, for the BIA, whomever it may be. It's not enough just to provide like one or two more things of evidence. You must provide a lot of evidence to show that the marriage is valid, to overcome that determination of marriage fraud. So, say you only submitted a little bit of evidence at first and then you decide to appeal the decision, that appeal should come with, explanations and a ton of evidence to back that up. Because, I mean, even if you think that you don't have a lot, any marriage that is valid, there should be something, there should be some trace of, the marriage. So you really have to make sure that you're putting all of that together when you're appealing any type of decision. Okay, let me go ahead and go to the next question. Can circumstantial evidence be used in a 204C determination? So it it can. Um, they don't necessarily have to have a smoking gun, and that's where you have to then overcome that with a substantial amount of evidence back. whether it is through USCIS or whether you're appealing the decision with the Board of Immigration Appeals. It must be substantial and probative. Let's see. And um, so while it can be circumstantial evidence that they use, they do have to have a lot of evidence to say that the marriage is fraudulent. Now, in some cases, they don't always do that, but that's why there's the ability to appeal. But then the evidence that you provide also must be substantial, and it must show that the marriage is valid. But before USCIS can conclude that, they are supposed to show that there's substantial evidence on the record. And they're supposed to cite certain things like that they found this in the record. They have to tell you, why they are giving you that determination. That is another BIA decision, I believe, where they have to tell you exactly the reasons why they are denying you. So if they talk to somebody outside of your house, like if they talk to a neighbor, they have to tell you that. If they looked up something in the public record, they have to tell you what they looked up and how, not necessarily how they found it, but what specifically they, what they found. Okay. The next question. What type of evidence does USCIS review in a 204C case? So, I mean, they can review anything. I mean, a lot of it is what they can pull up is a lot of public record, or the fraud prevention officers. Like I said, they can do kind of like detective work and go out into the field and be asking questions. They can review your answers at an interview. So it's always really good to make sure that you're prepared for an interview, because they can ask questions that you wouldn't even think of. And some things are, I don't want to be disparaging to men, but some men are not the best at remembering details of a relationship. Some women too, but sorry, men, I'm so sorry. But sometimes, in my experience, some men have trouble remembering like certain dates, or remembering certain circumstances, while women, we remember everything. But you need to be sure that you're on the same page before going into an interview, because when you go into an interview, you are opening up your relationship and showing it to USCIS. You're presenting it to them, and they can use that against you. So you really should make sure to be prepared. And then when you're trying to say refute there, or say you're responding to a notice of intent to deny, all of the evidence that they can review then, I mean, they're still going to take into account what they found, but you should always provide like an affidavit explaining all of the different points that they may have brought up, and then evidence to back that up. And I mean, anything that you can think of that could possibly prove your case, you should provide. I mean, if it's something that you might think is inconsequential, it's always good to go ahead and ask for the advice of an immigration attorney, because it's good for an immigration attorney to look and see at the case as a whole, and then kind of decide what evidence, could be helpful. And an immigration attorney can kind of look at your relationship and tell you, different pieces of evidence that you could possibly provide. Okay. I was on evidence. Okay. The next question. Okay, so what what triggers a 204C investigation? So again, that it can be anything such as if you didn't provide enough evidence of your relationship, of your living arrangements, um, and then employment records or public records. If they notice anything that's off, I think I've seen a case where it was when someone was applying for a job, they put someone else as their spouse, I believe. And USCIS found that and brought it up. I mean, things that you would not think that they can have access to, they find a way. So, I mean, they can even go to your job and ask them, "Oh, your coworker, do you know if they're married or who was at the last Christmas party or things like that?" I mean, things that you wouldn't necessarily think that they could find out, they can. So again, if you're really living someplace else and you're saying that you're living with your spouse, and then you put it on your driver's license that you're living at that other address, they're going to find that out. That's public records. Um, and then also, when you sign a lease agreement, they could even, request to see that lease agreement, and they can say, "Oh, well, you signed a lease agreement over here. Why are you saying that you're living here?" And then, "Oh, we talked to the people at that place. They see you over there all the time." So you have to be prepared to refute that type of evidence if it comes up. And Um, so, to sum it up, what can trigger a 204C is an inconsistency of records and the submitted evidence, and then answers provided during interviews as well. Uh, and another thing is always pay attention to the evidence that you're submitting because sometimes people, just kind of submit whatever they think could be helpful. And while I did say, yes, submit what could be helpful, review it and make sure that it actually is helpful. Make sure that there's no conflicting information on there. And uh, like for instance, a lease agreement. Make sure that if you're saying that you're both living there, that that lease agreement is signed by both of you. If there's initials at the bottom of every page, make sure that those are done, and then also provide a lease that's been signed by whoever you're leasing from. Because say you're saying that you're living with this person, but they're not actually on the lease agreement, that's going to hurt you, and they could bring that up, and that could trigger a 204C determination. Okay. Mhm. The next question: how does USCIS gather evidence of fraud? So, again, it's the evidence that you have provided. It is your answers during interviews. It could be any type of investigative method that they use from the fraud prevention officers, um, public records again, employment records. I mean, they're smarter than people think, and they have access to a lot of different types of um, databases. Thank you. Yes, databases that you wouldn't think of. I mean, they type you in like LexisNexis and get all sorts of stuff, and they utilize that. Okay, and then the next question: will USCIS notify the individual about a 204C determination? Yes. So they must notify you, and they must give you some type of explanation on how they came to that determination. So, again, if it was by an investigation, or they will even list out like the questions that were asked at an interview and put, for this question, the beneficiary said this, but the petitioner said that. and they will actually like list out those things. So they do have to provide you with the reasons and how they came about that determination. And they have to notify you. They can notify you first by a notice of intent to deny, and then you can go ahead and uh, have an opportunity to refute that, and then uh, or it could be by a decision. But when they issue the decision, I believe I said it earlier, the one that gets the 204C determination is typically the I-130. So it's the petitioner that's notified. So if you're not really in a marriage with the person or not in, on good terms with the petitioner, then it's unlikely that you're going to find out unless you actually speak with them or the petitioner provides you with that decision notice or with that notice of intent to deny. Now, if you're not really in contact with the petitioner, then you will see, like on your case status, that it was denied. And your own I-485, the decision notice for the I-485, will just say that it was denied because the I-130 was denied. So, okay. Okay. The next question. Yes, yes. And if you have an immigration attorney, then any communication that they send to the petitioner or the beneficiary, anybody that the attorney has a form G28 on file for, so that's an entry of appearance, anyone that there's a G28 on file for, the attorney will get a copy of, they're supposed to receive a copy of everything, whether it's a decision notice, an interview notice, a request for evidence. The attorney is supposed to receive copies of all of that. Now, we have seen cases where the petitioner gets it, but the attorney doesn't, but they are supposed to notify the attorney as well. You're supposed to be copied on, the immigration attorney is supposed to be copied on all of that communication. Okay. So the next question is, would you be deported if determined 204C? So the answer is a little bit more complicated than yes or no. So a 204C determination could lead to removal proceedings, which could mean that you could be deported. And part of what this decision is stating is that when you get into removal proceedings, you cannot argue against the 204C determination. So, another thing to point out, so while the court could still review the application, so say in the instance of the I-751, they can still review it. However, you cannot appeal further the decision of the 204C determination. So that's a big part of what this is that you can no longer appeal that decision further. Once the BIA makes that decision of 204C, it's final. So if you don't have any other relief and you get into removal proceedings, then yes, you would likely be deported. Because again, if you get a 204C determination and it's final, say it's, reaffirmed by the BIA, then that means that, first of all, you can't appeal that further. And second of all, you are barred from requesting for any other type of relief for life. So you don't have any other type of relief to seek in your removal proceedings, then yes, you will likely be deported. Because if you don't have a relief, then there's nothing that's going to keep you here. Because when you're actually in removal proceedings, that's one of the questions that you have to answer is, what is your relief? I know I've said that a few times, and I don't know if I've really explained that. So, relief is any type of status. So, it's any type of immigration status, whether it's a green card through an I-130, or if you are trying to get like asylum. Asylum is a type of relief. Um, yeah, cancellation of removal or withholding of removal. Um, any type of those things that will give you a status, that is a relief. Okay, I'm sorry. Just on that question, the attorney just sent me a message. So I just want to review this really quickly. Okay. So, in response to that same question, would you be deported if there's a 204C? The attorney says very likely, but if the applicant is eligible for another form of relief, like cancellation of removal, he may escape deportation. But now I need an answer from him. I'm sorry for this. Sorry, I'm going to put a pin in that because I want to double check something that he said and just to clarify. Okay, so just to clarify, okay, so for cancellation of removal, if you are eligible for that form of relief, you may be able to escape deportation because the requirements are different. Okay, hold on. I'm going to give him a call because I just want a clarification on this. Okay, I just want to clarify you are live on the podcast with me. Um, what you were just messaging me about cancellation of removal and the 204C determination. I understand that the requirements are different, but if you get a 204C determination and say it's reaffirmed by the BIA, if you're barred from an immigration benefit, how could you get cancellation of removal?
Section 204C says no petition shall be approved.
Okay.
Cancellation of removal is not a petition.
Okay.
It is EOIR 42B, application for cancellation of removal. So because it is not a petition,
then you can still be eligible.
204C
Okay.
does not apply to it. So the word is no petition shall
No
be
petition.
approved.
Okay.
And because cancellation of removal
It's not a petition. Okay. So as long as you meet the requirements, okay, of having a qualifying relative, of living here for 10 years and up until the time that you're issued the NTA, and then good moral character, no criminal record. Okay. Thank you. I just wanted to clarify that. Thank you so much for answering.
You're welcome. Thank you.
Okay. Goodbye. Okay. Thank you for, hanging in there with us. But I wanted to make sure that I clarified the answer to that question for you. Okay. So on to the next question. How can someone challenge a fraud finding? So you can challenge a fraud finding. It depends on where it's coming from. If like USCIS is issuing a notice of intent to deny and saying that they could issue one, then you can, refute that with evidence. Or if it's an actual decision that's made on the petition, then you can go ahead and appeal with the Board of Immigration Appeals. Now, when you are appealing, though, that brings us back to this decision. Like I've said a couple of other times before, with this new decision, once the BIA reaffirms that decision, that's final. So there's no more refuting it. There's no more arguing against it. That decision is final. But the way that you can try and overcome it with the appeal is by, as I've said before, providing other evidence or making an argument, if there's any legal arguments to be made, anything, it would have to be specific to your own decision. But the short answer is an appeal. Is there any time limit on 204C findings? I don't understand. Oh, like once you're granted. Oh, okay. Yeah. No, that's barred, permanent bar. Okay. Does 204C apply to relationships other than marriage? Like a fiance? Well, because you can get a 204C determination if you entered into that marriage, or if you entered into that marriage with the intention of committing immigration fraud or getting an immigration benefit. So it has to be based on a marriage, but it could be on a previous marriage that there was no petition on. So say, you had previously entered into a marriage solely for the benefit of, or solely for an immigration benefit. And even if you don't actually seek any type of application or petition on that marriage, just the intention of doing so can lead to a 204C determination. And those are really hard to overcome because, that's a past relationship. It's not even a current one. So that is possible, but it would have to be on a marriage, because you have to, at the time that you enter into the marriage, you have to be entering into it for the benefit or for an immigration benefit. That's how you get the 204C finding, entering into the marriage, not in good faith. Okay, the next question. What if the marriage was bona fide but ended in divorce? So, if the marriage was bona fide, meaning it was not entered into for, solely for the purpose of an immigration benefit, and say it was entered into in good faith, then you can still prove that even if it ended in divorce. It doesn't matter how the relationship ended, it matters what it was at its inception. At the time that you got married, what was your reason for getting married? Was it for love, or was it solely for the purpose of an immigration benefit? So that's really what matters. It's not how it ends, it's how it began. Okay. And then the next question. Does 204C apply if the fraud was in a prior marriage? Yes. I started answering that before. But yes, even if it was a prior marriage, so like I was saying, even if you did not apply for anything based on that marriage, if that spouse never petitioned for you, but if it was entered into solely for that immigration benefit, then yes, they can come after you. And in circumstances where it ended, badly in divorce, or say even if the person passes away, then you still have to overcome that determination. And again, that's something that's really difficult to do if you don't have the cooperation of the person, whether it's, you know, through divorce or through death. So it is possible that you could overcome that and appeal that decision, but it is very difficult to overcome when you don't have the cooperation of that person, because then you're having to go on your own word and then any evidence that you can provide. So it is possible that you can overcome that on appeal, but just know that you have to have a very good case and you do have to prove that that marriage was bona fide. Okay. So I think that's the end of our questions. I don't think we have any more questions right now. So um, I just want to, hmm? Yeah, yeah. I just want to go ahead and thank everyone who tuned in today. Thank you for sticking with me. I know I am not Dr. Asekun. Um, like I said, he was unavailable today, but thank you so much for tuning in. And again, you can join us live every Wednesday at 12 p.m. Central Standard Time. And you can also follow us on social media, get different updates about the office, get different, posts that we do. Go ahead and follow us on Instagram, TikTok, whatever social media is your favorite. I like Instagram the best. And then subscribe to us on YouTube, because then you can get notified every time that we go live. And that's really helpful. So then you can tune in, but people also tune in later because not everyone's available right now. So yeah, just go ahead and tune into us every Wednesday at 12 p.m. Central Standard Time. And I think our Instagram handle was posted before. Okay, it's up on the screen again. So go ahead, make sure to follow us there. And if you have any questions that you want answered about this topic or even about something else, go ahead and send them to 817-883-4495. We do check that phone, and we do make sure to compile those questions. If we're not able to answer it live, then we compile them and we answer them in possibly a question or answer series. Or you can always post your questions, into our live chat, and we will do our best to answer all of them in the time allotted. So again, thank you for tuning in. I hope that you have a great week ahead.